Keli Lane, born on March 21, 1975, is an Australian former water polo athlete and educator who was found guilty of the tragic murder of her newborn daughter, Tegan, in 1996, alongside 3 counts of making false declarations. On April 18, 2011, her legal team filed an appeal against her conviction, coinciding with a claim from a Sydney taxi driver who alleged he witnessed Lane disposing of her child. Ultimately, her final appeal was denied by the High Court of Australia in August 2014. Lane is the daughter of Sandra Lane, a former hospital employee at Manly Hospital, and Robert Lane, a retired police officer. She received her education at McKellar Girls High School in Manly before enrolling in an arts program at the University of Newcastle, which she left to pursue a part-time position as a water polo coach at Ravenswood School for Girls. Her impressive credentials were recognized in the school yearbook, where she was noted as a degree-qualified teacher with honors. Between 1994 and 1998, she was romantically involved with rugby union player Duncan Gillies. A distinguished water polo player, Lane was part of the Australian junior women's team that secured a silver medal at the 1995 World Championships in Quebec, Canada, competing just months after placing her first child for adoption. During her trial, the prosecution contended that Lane experienced 5 pregnancies over 7 years in the 1990s, terminating the first 2, placing the 3rd and 5th children for adoption, and allegedly murdering the 4th. After 4 unsuccessful attempts to induce labor at Ryde Hospital, Tegan Lee Lane was born on September 12, 1996, at approximately 38 weeks at Auburn Hospital. Less than 48 hours later, Lane left the hospital with Tegan around midday and returned to her parents' home alone by 3 p.m. Later that day, she attended a friend's wedding, elegantly dressed in white alongside her partner, Duncan Gillies. Any indication or reference was absent to Tegan. In 1999, Lane, who was 25 weeks into her 3rd pregnancy, traveled to Queensland in pursuit of a late-term abortion. Her request was denied due to the fetus being at a stage of viable gestation. 3 months later, in May 1999, Lane welcomed a son whom she chose to place for adoption, mirroring her decision with her first child in 1995. She informed a social worker that this was her firstborn and that Gillies was the father, a claim Gillies refuted. Before the child could be permanently placed, a child protection worker from the Department of Community Services, DARCS, conducted further inquiries, revealing that the child born in 1999 was not Lane's first. It was discovered that she had given birth in 1996 at Auburn Hospital. Additional investigations uncovered that Lane had also welcomed a child in 1995 during her 4-year relationship with Gillies, who professed ignorance regarding Lane's pregnancies. When faced with these accusations in October 1999, Lane initially denied the existence of her 2 earlier children. However, a few days later, she asserted that her daughter was residing with a family in Perth. The situation was subsequently referred to local authorities, who initiated investigations in late 1999. By February 2001, Lane, now 7 months pregnant with her 4th child, was interviewed by the police. During this interrogation, she claimed to have entrusted Tegan to the child's father, a man named Andrew Norris, or Morris, with whom she alleged to have had a fleeting affair. Lane recounted that this liaison occurred at a unit in Balmain on Friday evenings, following a drinking session at the town hall pub known as the Townie. In her police statements, Lane mentioned that Norris's long-term partner, Melanie, also resided there, as she frequently observed women's clothing scattered throughout the unit. Lane noted that while Melanie worked in retail, she was absent from the unit on those Friday nights. During police interviews, Lane expressed that she felt compelled to conceal her pregnancies due to her apprehension regarding the reactions of her parents and friends, as investigations revealed her uncertainty about the identities of the fathers of her children. She initially stated to the authorities that she had entrusted the baby to Norris in the parking lot of Auburn Hospital, but later revised her account to assert that the handover occurred within the hospital's foyer. Throughout the interviews, Lane repeatedly conveyed a sense of isolation during her pregnancies, and in a monitored phone conversation with her mother, she lamented, "I had no other choice," alluding to her decision to give the baby to Norris. In 2005, the Manly police escalated the case to the New South Wales coroner. A coronial inquest into Tegan's disappearance commenced in June 2005 and continued until February 2006, overseen by State Coroner John Abernethy. The inquest revealed that law enforcement had conducted a thorough search for the child, including efforts to match DNA samples. Ultimately, the coroner concluded that he was comfortably satisfied that Tegan Lane is deceased, and expressed concerns regarding the possibility of foul play, while also acknowledging the slim chance that she might still be alive. The coroner mandated the issuance of a death certificate for Tegan and recommended that the evidence and transcripts from the inquiry be forwarded to the New South Wales Homicide Squad for further evaluation and potential investigation. From 2006 onward, police efforts concentrated on locating Norris, Melanie, Mel, and Noeline, Nana, Norris, the mother of Andrew Norris, all of whom were alleged to have been involved in or witnessed the transfer of baby Tegan from Auburn Hospital. Despite 9 documented accounts of the events of that day, it was reported that authorities were unable to identify any individuals matching those descriptions. Reports of sightings of Norris at the Sydney Aquarium were ultimately dismissed. Caroline Caro Meldrum Hannah, in her commentary following the ABC Exposed documentary, recounted that Lane had expressed to her that Andrew had no interest in water. In their pursuit of Tegan Lane, police meticulously combed through the records of over 9,000 primary schools across Australia, a painstaking investigation that spanned 2 years. They identified 2 girls named Tegan Lane in Queensland and another potential match on a Torres Strait Island, yet ultimately ruled out all leads. With no definitive or physical evidence indicating Tegan's demise, the police opted not to file charges against Lane. However, they escalated the case to the New South Wales Director of Public Prosecutions, Nicholas Cowdery. In a move described by the National Times as an unusual step, Lane was charged with her daughter's murder on 17 November 2009. Lane entered a plea of not guilty, leading to a jury trial in the Supreme Court, overseen by Justice Anthony Wheely, with Mark Tedeschi, QC, representing the Crown, and Keith Chappell, SC, defending Lane under the auspices of legal aid. The trial commenced on September 9, 2010. The prosecution contended that Lane had experienced 5 pregnancies over 7 years during the 1990s. She terminated the first 2, placed 2 infants for adoption, and allegedly took the life of her baby, Tegan, on 14 September 1996. The jury was informed that Lane had concealed her pregnancies from her family and friends to safeguard her image and reputation. Supreme Court Judge Peter Hamill, who had previously defended her in 2006, noted that revelations about her tumultuous romantic life, particularly involving several rugby players from the Manly Marlins club, would have severely tarnished her reputation. The evidence presented during the trial mirrored that which had been disclosed at the inquest 4 years prior. The primary distinctions in this case revolved around the police investigations that transpired in the interim, alongside the revelation that Lane had departed from Auburn Hospital not at 2 p.m. on the day Tegan vanished, but rather several hours prior. The Crown presented compelling evidence suggesting that Lane, motivated by her aspirations to represent Australia in water polo at the Sydney 2000 Olympic Games, was willing to forsake her children at birth. Furthermore, it was indicated that she perceived motherhood as a hindrance to her academic pursuits, social engagements, and the esteem in which she was held by peers and family alike. Additionally, it was posited that the wedding of a close friend on the 14th of September may have played a pivotal role in her decision-making, as Lane sought a definitive resolution to conceal the evidence of her pregnancy and childbirth from those around her. On 13th December 2010, the jury found Lane guilty of perjury concerning documents related to the adoption of 2 other infants. However, they could not reach a unanimous decision regarding the murder charge. Following counsel from Wheely, the jury was permitted to deliver a majority verdict of 11-1. Later that same day, they ultimately convicted Lane of Tegan's murder. Bail was denied, and sentencing proceedings commenced on the 11th of March, 2011 in the Supreme Court, where the Crown urged the court to emphasize general deterrence. Reports indicated that psychiatrist Michael Diamond, who testified for the Crown, found no signs of a psychiatric disorder, suggesting that Lane's actions were driven by a problem-solving mindset. On 15th April 2011, Lane was sentenced to 18 years in prison, set to conclude on 12th December 2028, with a non-parole period of 13 years and 5 months, making her eligible for parole on the 12th of May 2024. Subsequently, Lane's legal representatives filed an appeal against her conviction on the 18th of April 2011. On the same day, media reports emerged claiming that a taxi driver had witnessed Lane disposing of a baby in the bushland while en route to Manly. Recent reports suggest that Lane has faced violence from fellow inmates since her incarceration, resulting in injuries to her face. Lane has refuted these claims. An appeal was filed and subsequently heard in the New South Wales Court of Criminal Appeal from July to December 2013. The court ultimately dismissed the appeal, stating that there was ample evidence supporting the jury's verdict of Lane's guilt. Following this, Lane sought permission to appeal to the High Court of Australia, but her request was denied in August 2014. On 22 March 2024, Lane was denied parole under the No Body, No Parole legislation of New South Wales. As long as this law is upheld, and until Lane can demonstrate satisfactory cooperation with police investigations regarding the whereabouts of Tegan, she is expected to remain in custody until her sentence concludes on the 12th of December, 2028. In 1993, John Asquith found himself entwined in a relationship with Byers, and together they embarked on a luxurious yacht excursion across the serene waters of Moreton Bay. Following an exquisite dinner accompanied by fine drinks, Mr. Asquith retired for the night. In a chilling turn of events, it is believed that Byers orchestrated a sinister scheme to claim Mr. Asquith's life insurance. While he lay asleep, she callously shot him in the head at close range with a sawn-off shotgun. However, fate intervened as Mr. Asquith miraculously survived the brutal attack, managed to alert the Coast Guard, and later bravely testified against his partner in court. The incident raised police suspicions regarding Byers' past relationship with Karel Gotkins, a 51-year-old man who had vanished in 1990 while involved with her. In 1999, Byers was convicted of Mr. Gotkins's murder, yet his body was never recovered. Now 72 years old, Byers has made 4 attempts for parole over the years, with concerns mounting that her latest endeavor may succeed. In 2009, she was relocated to a South Australian prison to be nearer to her son, Alan Byers. The introduction of the No Body, No Parole law in South Australia in July 2015 has since barred convicted murderers from being considered for release if they withhold information regarding the location of a body. In a bid to bolster her chances for parole, Byers confessed in 2016 to the murder of Mr. Gotkins, claiming she had struck him in the back of the head with a machete at Queensland's Logan River in July 1990, causing his body to slip into the water. Yet, doubts linger regarding the veracity of her confession. "We searched following her revelation," stated Acting Superintendent Damian Hansen at the time. "No remains were found, and we have duly reported that." During her initial trial, Byers had claimed that Mr. Gotkins had left her for another woman, asserting she was unaware of his whereabouts. Their relationship had spanned 8 years before his mysterious disappearance, and investigators suspected that Mr. Gotkins had met his end at their home, as traces of his blood were discovered within the couple's residence. Byers was discovered to have engaged in the forgery of documents to unlawfully claim ownership of Mr. Gotkins' opulent residence and yacht. The children of Mr. Gotkins from a prior marriage contested these alterations, successfully restoring the deeds to their father's name. In a similar vein, Byers also falsified Mr. Asquith's signature on numerous life insurance policies, positioning herself as the exclusive beneficiary of his estate. Given the parallels in Byers' criminal background, there are suspicions that additional victims may exist. Concerns have even been raised regarding the circumstances surrounding her first husband's demise, which occurred during a shooting outing. Keli Lane, executive editor of True Crime Australia, shared these insights on Weekend Today. At a young age, Byers was residing in Darwin with her 2 sons and husband when tragedy struck. Ms. Lane further noted the tragic fate of Byers' eldest son, who lost his life in a motorcycle accident while she was at the helm, resulting in a horrific decapitation. She possesses an extraordinary talent for manipulation coupled with a remarkable criminal intellect, Ms. Lane remarked. Most Australian states have embraced the no body, no parole legislation, and should Byers be granted release, the families of her victims harbor grave concerns for their safety. As the clock approached 8:30 p.m., Louise Bell and her younger sister Rachel bid their parents good night, retreating to their beds in the modest front room of their Adelaide residence. The sultry January evening of 1983 prompted a slight opening of the window, allowing a gentle breeze to filter in. At the break of dawn, around 6 a.m., their mother peeked in to check on her daughters. While Rachel remained peacefully asleep, the bed of 10-year-old Louise was conspicuously empty. After a thorough search of the home, Diane awakened her husband, and together they discovered a chilling sight in the sisters' room that compelled them to contact the authorities. The fly screen above Louise's bed had been severed at the corner, creating a gaping hole that fluttered in the wind. The police swiftly organized a search effort, but after 6 hours and 2,500 door knocks, they uncovered no leads. The sudden disappearance of Louise from the safety of her suburban Australian neighborhood sent shockwaves through the community. As ABC reporter Candice Prosser recounted on Mamma Mia's True Crime Conversations, "This was an event that seemed unimaginable. This little girl went to sleep beside her sister in their family home, and by morning, she had vanished, taken from her bed. It was utterly unfathomable that a child could disappear in such a manner without a trace." 2 weeks following Louise's mysterious disappearance, a local woman received an unsettling anonymous call from a man with a European accent. He asserted that Louise was alive, content, and unwilling to return home, yet claimed she was unwell. He derided the police investigation and instructed the woman to a broken brick at a nearby intersection, alleging he had left the little girl's earrings there. In a swift response, police located Louise's gold hoop earrings just a 4-minute drive from the Bell residence, yet they were unable to trace the mysterious caller. 2 weeks later, the same woman who had received the ominous call discovered the yellow pajama top that Louise had worn the night she disappeared, lying on her front lawn. The fabric had been tattered, soiled, and drenched. Later that same year, law enforcement shifted their focus to Raymond John Giesing, prompted by revelations from prison informants who alleged he had confessed to them while incarcerated for unrelated offenses. He received a life sentence for the abduction and murder of Louise, yet this conviction was overturned 17 months later when a pivotal witness altered his testimony. Giesing would eventually find himself imprisoned once more for the sexual abuse of two sisters in the 1990s. By 1989, authorities had turned their attention to another possible suspect in the murder of Louise Bell. Dieter Pfennig, a high school mathematics and science educator, was convicted that year for the murder of a 10-year-old boy and the sexual assault of a 13-year-old. His daughter played basketball with Louise, he resided in proximity to the Bell household, and his German accent matched the description provided by an anonymous caller. However, the police lacked substantial evidence to connect him to her abduction. Decades later, investigators revisited the cold case, and in 2011, they dispatched samples from Louise's pajama top to the Forensic Science Center in South Australia. The results indicated a probability match that did not exclude Pfennig. Subsequently, the samples were sent to a highly advanced DNA testing laboratory in the Netherlands, where they confirmed a match to Pfennig with a staggering probability of 1 in a billion. On November 19, 2013, Pfennig was charged with the murder of Louise Bell based on this new DNA evidence. His trial commenced in 2015, and journalist Prosser, who reported on the proceedings for the ABC, remarked to True Crime Conversations, "It was remarkable for so many reasons. This case has always lingered in my memory. I doubt I will ever forget it. The stakes felt incredibly high, and after such a prolonged search for answers, this was finally the moment for justice to begin its long-awaited journey." Pfennig maintained his innocence and was tried by a judge alone. The prosecution depicted him as a man who had spent years fixated on revisiting and discussing the crime. In the course of his teaching, he would often reference the case as a pastor and a fellow inmate testified that he had confessed to the murder of Louise. Additionally, a taxi driver provided testimony, recounting how he transported Pfennig to the Bell family residence, where he observed him lingering outside, smoking a cigarette. However, it was the irrefutable DNA evidence that ultimately led the judge to convict Pfennig in 2016, imposing a sentence of 35 years without the possibility of parole. When combined with his prior convictions, Pfennig faces a minimum of 60 years in prison, making him 103 years old at the time of his potential release. As Prosser articulated, even nearly 40 years later, the judge noted the immense publicity and distress this case caused within the community. The South Australian populace was profoundly shaken by the events. It was simply incomprehensible. The judge did extend an opportunity for Pfennig to disclose the whereabouts of Louise's remains before sentencing, yet he declined. This refusal adds to the myriad of unresolved questions surrounding the case, particularly regarding the manner of her abduction. Given that her sister was merely a meter away and her parents were just a room away, the judge suggested that Louise was likely lured from her bed rather than forcibly taken. Pfennig was not only a local teacher but also the father of Louise's friend, a figure once held in high regard within the community. There exists no plausible explanation for how Louise could have been taken under such circumstances without anyone being aware, Prosser remarked. There are numerous facets of this case that may forever remain shrouded in mystery. When was Louise taken? How and when was she murdered? Ultimately, the judge concluded that he was convinced beyond a reasonable doubt of Pfennig's guilt, and he did not need to resolve those specific inquiries to reach his verdict. As Justice Michael David conveyed to Pfennig during sentencing, his actions constituted the most heinous of crimes, and the passage of time in no way mitigated its severity. The profound shock and anxiety your actions have inflicted upon the South Australian community pales in comparison to the unimaginable distress endured by the parents and family of Louise Bell. Consequently, the outcome of my sentencing will ensure that you will undoubtedly spend the remainder of your life behind bars.